9158 General Grant Lane. My questions are for the city attorney, and both publicly and privately with you, you're well aware of my concerns about the change in the political activity language in the civil service rules, in large part due to the fact that we're using language in the charter which, by your own admission, is vague. And I think we both agreed at a previous meeting that that language can be interpreted broadly or narrowly so that either it will allow employees to take part in political activity in Crestwood or it prohibits them. Would you agree with that?
I agree that that the language can be interpreted in any number of ways.
Okay. And then, so your remedy is to have the board come up with guidelines if you're going to choose to interpret it so that they can participate off hours when they're not working in Crestwood political campaigns. That the idea was to come up with some guidelines. Is that correct?
I don't know what the first part you just said, but guidelines, yes. I've never endorsed promoting what you suggested in the first part of your statement there. That's up to the board.
Well, you said back in August such a broad interpretation of the charter would be a violation of First Amendment rights. The way it was read, if you prohibit the employees from partaking in political campaigns in Crestwood. Back in August of '09, that's what you said. And that's where you made the assertion that you interpreted an expression of political or an expression of opinion to mean that you could campaign when you were not working.
I don't believe
those were your words.
I don't believe it.
Okay, well, you can check the record, but those.
I'm not the person that's going to decide what the guidance is.
I understand,
okay?
but
this
this.
By the Civil Service Board and/or the Board of Aldermen. So.
I understand. Since you recommended making guidelines at the last meeting, the board ended up with the mayor breaking the tie, voting against Alderman Wallach's recommendation to have you drop the guidelines. So there's no guarantee that at this meeting the board will vote in favor of having those guidelines. So I'm here because I am concerned and I do have questions as far as that language. What understanding does the firefighters union have of that charter language?
I can't speak for the firefighters.
What, did you give them any particular interpretation of that language?
Never discussed it in this.
But that's what.
Round of negotiation. Never came up.
It didn't come up.
Never.
When you were doing the political activity and you were referring to the charter, no questions were asked about the language in the charter.
We had our language in the agreement, and they said it was fine.
The language refers to the charter.
Correct.
And they didn't ask what's in there.
Well, I'm assuming they read the charter.
But you don't know how they you don't know how they interpret it.
I have no idea how they interpret it.
Okay, so the city doesn't know how the firefighters are going to treat Crestwood firefighters in local campaigns.
We don't know how. We don't have any idea how they would have treated them under the prior language. You'd have to ask the firefighters.
But shouldn't the city know whether the firefighters are going to be allowed to participate in local campaigns?
Shouldn't the city know?
Yes.
Well, I don't understand that. I mean, the city. How would the city know what the firefighters think they can or cannot do?
Well, because it's part of you're mirroring the charter language, and eventually you're going to, the hope was to develop guidelines. If those guidelines don't get developed, you have a piece of what you have admitted is vague language in the firefighter's contract. So nobody knows which way it's going to be interpreted.
Well,
my
guess is that that the only way that we'll ever find out what the lawful interpretation is if a firefighter or the firefighters union challenges the language. So You know, they had the charter, they read the charter language. You weren't here 4 weeks ago, but the gentleman from the representative of the union spoke. So they're going to interpret it the way they interpret it.
Okay. And is it your opinion that the existing civil service language regarding prohibited employee political activity in which they may not participate in a city election except by individual ballot represents a violation of First Amendment rights?
The language could be better.
Okay. And is this proposal to change the current language to mirror the charter being done in part because of your belief that the current civil service language is inconsistent with the charter?
Yes, in part.
Okay. And would you say that is over a First Amendment rights issue? The freedom of speech, political expression?
Could be.
Okay. As Alderman Miguel mentioned, in 2007, the Board of Aldermen held a 3-hour work session to consider just the civil service rules. And the board members at that time, you were there at the work session, the mayor was there, Alderman Pickle was there, Alderman Miguel was there. Reviewed the document section by section, and prior to that meeting, the Civil Service Board had been in contact with you to make sure that all the documents in the city were consistent. I believe we even made a matrix for you of the overlapping issues across the documents. And at that time, not a single person during that work session brought up any issues about the political activity section. And if it's your contention now that these changes are being done in part because of a violation of First Amendment rights, I would think that would have been a huge red flag, that would have been an obvious point to catch that we're violating the First Amendment rights by having the phrase "may not participate except by individual ballot." But nobody said anything, including you. And this is actually what you did say when you were asked. Alderman Roby asked the city attorney if the document is in agreement with all federal laws and legislation. Rob Golterman, city attorney, stated that it does and that it is also in agreement with the city of Crestwood's charter. That was the understanding back in 2007, which means that you agreed that language, the one that's currently in the civil service rules, does not violate the First Amendment rights, which is not what you're saying today. So I think in order to be fair to this board, you've got to decide and let them know, is it a violation or is it not? Is it consistent with the charter or is it not? You're saying two different things within the span of 2 years. And I think the board is owed an explanation. Which opinion do you stand behind? Because you were asked to review this document, the civil service rules, on its own in detail in 2007. The only reason things are changing in 2009 is because this is being looked at through the lens of the negotiations with the firefighters union. So before the board can make a vote on this issue, I think you need to clarify your advice. Are you going to stick with the advice you gave in 2007 or the advice you're giving in 2009?
Fortunately, Ms. Duchow, I don't stop learning, okay? Fortunately, I'm open to enhancing my legal abilities, and fortunately, I continue to educate myself in the area of municipal law and constitutional law, and I don't close my mind off. So occasionally I become smarter and more educated, and that may have been the case here. And if the board wants me to provide an explanation, I'd be happy to do so. Whether you think I owe the board an explanation, I really don't care.
Thank you.